Permeate more and more areas of international law, also of the traditional interstate kind, issues of and related to human rights will necessarily present themselves also to the court with increasing frequency. This has become apparent by the marked increase of respective cases within the last few years. So until now, this is a prognosis which is essentially quantitative. We are on safe ground to predict that in the future the court will have even more occasions to develop its human rights jurisprudence than it has had so far. The court has been increasingly supportive of human rights claims, and it has demonstrated that it can handle human rights in a way considered respectable also by the droit de l'hommiste. In this regard, it has caught up with the existing human rights courts. This leads me to a qualitative assessment, to the question, is there something the ICJ could do in the field that the specialized courts cannot do, or that the Hague Court might be able to do better? Now let me start, this is the final point of my presentation, with a word of caution. Human rights are and will remain a field in which the court ought to tread with utmost care. This admonition is appropriate for at least two reasons. The first is to be seen in the great advances of international human rights law brought about by the regional human rights courts, and to a certain degree also by the non-judicial institutions in the UN human rights system. These actors have developed doctrines and rules custom-made for human rights, for instance with regard to the interpretation of human rights treaties and other questions of treaty law, which might go too far to more conservative circles of the legal mainstream. This acquis must not be leveled by the participation in the discourse of a generalist court like the ICJ. The second reason why the ICJ ought to be careful about its role in the human rights field lies in the socio-political basis of the court in the international community of states. In a certain sense, the ICJ is the permanent international court which still resembles most closely a system of dispute settlement by voluntary arbitration from the viewpoint of the freedom of states to have recourse to it. Its contentious jurisdiction is still strictly consensual, and compared with the working of more recently created judicial bodies, especially at the regional level, the functioning of the Hague Court shows a distinctly more pronounced respect for the sovereignty of its users throughout. Thus, could we exclude that at least a part of its clientele might be somewhat less than enthusiastic if the ICJ assumed features of a human rights court or more pronounced features of a human rights court? Could the consequence be a loss of popularity with some of its best customers? Speaking frankly, most states, that is not only the usual suspects in the eyes of Western observers, all too often behave like foxes guarding the chickens in human rights matters, and are thus rather reticent towards the idea of truly effective international third-party adjudication of human rights problems. International human rights are a permanent nuisance and very often a threat to the holders of political power. If the court, to whose compulsory jurisdiction states might have consented with the expectation that what they could possibly get involved in would be interstate litigation of traditional type, if the court began to broadly accept, to give just one example, applications or interventions by states other than injured states in the sense of the ALC draft articles on responsibility, this might come as a rather unpleasant surprise to many of its clients, not all of which count among the most human rights respecting countries. After all, the development of international human rights will not infrequently upset sovereignty-based rules of international law, with which most states will have been and still are very comfortable. What then is a proper role for the court? Now, in my view, the most valuable contribution the ICJ can make to the international protection of human rights, a role for which it is particularly well equipped and practically has no competition, consists in what could be called the juridical mainstreaming of human rights in the sense of integrating this branch of the law into both the fabric of general international law and its various other branches. The Court can render human rights arguments more readily acceptable to international law generalists by interpreting and applying substantive provisions of human rights treaties in a state-of-the-art way, compared, for instance, to the reading given to such provisions by certain general comments given by UN human rights treaty bodies, all too often marked by a dearth of proper legal analysis, compensated by an overdose of wishful thinking. Further, the Court is singularly capable of devising solutions for practical, more technical legal problems which arise at the interface between human rights and more traditional international law, and thus could pave the way for the acceptance of human rights arguments and more generally supporting and developing the framework of human rights protections. The Court has already made considerable contributions in this regard, even though with varying degrees of success or constructiveness, depending on the viewpoint of either the human rights-minded or the statist observer. Let me mention the following issues just mentioned, in regard to which the Court has already engaged in what I just called mainstreaming. First, in its recent case law, the Court has clarified the nature of obligations flowing from human rights treaties, in the sense that these obligations create correlative rights and rights not only for individuals, but also for the other states parties to these treaties, which these parties may enforce or vindicate in judicial proceedings. Second, the Court has made decisive contributions to the development of the law on reservations to human rights treaties and several other treaty law questions applying particularly to human rights treaties. Third, in concert with the jurisprudence of regional human rights courts and UN human rights treaty bodies, the ICJ has clarified the territorial scope of human rights treaty obligations. Fourth, the Court has contributed to the development of a doctrine of positive obligations in the area of human rights by giving contours particularly to the obligation of prevention, and I refer particularly to the genocide case. 5, in several decisions, the Court has dealt with questions of attribution to a state of human rights violations by non-state actors. 6, the Court has clarified the relationship between human rights law and international humanitarian law. Well, some of you might take the view that you cannot really call this clarification, but the Court has dealt with that matter. 7, in its very recent case law, the Court has dealt with the relationship between treaty-based implementation procedures foreseen in human rights conventions and its own jurisdiction, Congo, Rwanda, and Georgia v. Russia. 8, following a rather unpromising start with regard to the setting of priorities between human rights considerations and other rules of international law, particularly state immunity, the Court is currently facing a new possibility to develop its case law on this matter, Germany v. Italy. 9, the Court has already adapted rules on state responsibility for internationally wrongful acts to the special situation of human rights violations. And 10th, and finally, and more generally, the Court has accepted and developed what I would call international legal vehicles, Professor Brownlee's famous cars in the garage, which were then put to use with regard to human rights obligations. I referred to the category of use Kogan's and doctrinally connected with such higher law, that the category of obligations erga omnes. Thus, if we wanted to find a short-term description for our topic of the ICJ and human rights, we could call it an instance of international legal discourse in which old international law, represented for our purpose by the Court, encounters new international law. What we can observe already is that the Court has become a major player in a process in which human rights and general international law mutually impact upon one another. Human rights modernize international law, while international law mainstreams or domesticates human rights. Thanks for your attention.
Grazie. Io vorrei innanzitutto ringraziare la SIDI, ringraziare il professor Sapienza di avermi invitato a questo convegno a parlare in questa prima sessione insieme al collega e amico professor Simma, riannodando una vecchia amicizia ma anche interazione che abbiamo avuto in passato nei comitati sui diritti umani nelle Nazioni Unite, lui al Comitato dei diritti economici, io al Comitato dei diritti civili e politici. Il professor Sapienza mi ha chiesto anche di parlare in inglese, quindi farò la mia relazione in inglese e passo adesso all'inglese. I have a long text, but don't be afraid, I will not read it out. I will try to make some points, and if they will not be exhaustive, you will find the text later on in the publications of the SIDI. My perspective is quite different from the perspective of Professor Simma, or Judge Simma, because unlike other international courts, including the ICJ, whose primary objective is the settlement of international disputes, international criminal courts have been established in close connection with human rights protection. So they deal with human rights protection and have been established as a reaction to serious violations of human rights, either due to grave breaches of international humanitarian law during an international or non-international conflict, or due to the widespread or systematic violation of human rights, again in connection with an armed conflict, or more recently even without such a connection. The main purpose of international criminal courts is therefore to fight impunity for gross violations of human rights. Although their establishment has been associated with other goals, such as putting an end to a conflict, or favoring the end of a conflict, or restoring trust and reconciliation in a society torn by a conflict and violations of rights, as the examples of the ICTY and the ICTR. I don't have to explain the acronyms. I think they are known to everybody. But it is a fact that international criminal courts have started working in that perspective, and the first examples of the ICTY and the ICTR established in 93 and 94 by the Security Council has been followed by many other examples, at the point that it's difficult now to control all the proliferation of criminal courts that has taken place in the last 15 years. And even the adoption of the Rome Statute of the International Criminal Court as a permanent court has not stopped the proliferation if we consider that after the adoption of that statute in 1998, the panels of the UN administration in Kosovo has been established, the Special Court for Sierra Leone has been established, the special panels for East Timor have followed, the extraordinary chambers in the courts of Cambodia, and lastly, the Special Tribunal for Lebanon. And who knows whether this trend towards new courts, new criminal courts, is over, or whether it will continue, not necessarily referring to crimes that preceded the Rome Statute, which is obvious that the ICC is not able to deal with these crimes, but even concerning crimes committed after that statute. Be as it is, all these courts, and I will not go into details on each of them, deal with human rights. And the purpose of these courts, essentially the role, is to fill a gap in the international system of human rights guarantees that up to now, as you all know, has consisted mainly of procedures directed towards states in order to ensure protection of human rights within their respective territories and jurisdiction. But the system, international system of human rights, whether universal or regional, had not dealt completely, occasionally maybe, but not systematically, with the agent of the state, with the responsibility of the agent of the state, who personally is responsible for the violation of the rights. It remains for the state to take action against the perpetrator if the state so wishes. It's true that human rights bodies have frequently recommended states to criminalize the violation of the rights, but not necessarily states do it. And there is no clear obligation in the Human Rights Treaty on criminalization. There is a clear indication, a clear obligation to criminalize serious violations of international humanitarian law, but there too, at the end, many states have not taken that obligation very, very seriously. Now, the establishment of international courts fills in a gap in the sense that if states do not take seriously that obligation to criminalize violation of, gross violation at least, of human rights, the international courts will jump in and take that job and try the person that may be responsible. Now, the problem is that if the international community takes, through the Security Council or through treaties or other bodies, takes the administration of justice in its hands, trying and punishing perpetrators of serious human rights violation, the international community must act in conformity with human rights standards. And this is the challenge, essentially, because it's easy to say that perpetrators of serious crimes will be tried internationally instead of being tried at the domestic level, but it's not equally easy to try internationally with the same, applying the same standards that are applicable at the domestic level. And this has two dimensions. On one hand, the dimension of the applicable law, or the applicable criminal law, and on the other hand, the dimension of the procedural law. And both are critical. I will not dwell much on the substantive law. The problem with the substantive law is essentially the respect for one of the basic principles in criminal law, which is the principle of legality. It's well known that the law, criminal law, must be certain, must be foreseeable, must exist at the time of the commission of the crime, cannot be retroactive, and this is a principle that nobody has ever challenged. Now, establishing courts, as the international community has done, after the commission of crimes, means that the act that establishes the court, be it a treaty or be it a resolution of the Security Council or an agreement within the Security Council and the state, cannot describe in detail the crimes that have already been committed. In any case, that act cannot function like a code, like a criminal code, because its application would be retroactive to the moment of the commission of the crime. That led the Security Council, when it first dealt with this problem, to rely on customary law. So you find the statutes, the agreements made with the Security Council, which just spell out the list of the crimes that come within the jurisdiction of the court, but there is no indication of the elements of the crime, of the scope of the crime. There's just a name: torture, persecution, killing, but the elements of the crime that you find in any criminal law, in any criminal code, are not described in the statute. Rather, there is a recommendation of the Secretary General in the document, in the proposal of accompanying proposal of statute of the ICTY, but the same applies to the ICTR, to apply rules that are no doubt binding under customary law. It's easy to say that, it's less easy to do that. There is a paradox in a way. The paradox is that we are used to consider a law certain, having characters of certainty when it's written. And in order to have a law which is certain, the recommendation is to apply a law which is non-written. Because even states who rely largely on customary law, when they come to criminal law, they normally issue acts in which the elements of the crime are clearly described. I don't have to explain the difficulty of applying customary law or of checking whether treaties that exist match exactly customary law or do not match exactly customary law. This is an operation which is always difficult to do for any international lawyer. Is more difficult to do from the point of view of a criminal jurisdiction than from the point of view of a judicial body like the ICJ, for instance, where some development of the law may be accepted, while in criminal law, any development of the law should be discouraged because would run against the principle of legality. And this, if you look at the case law of the ICTY or other tribunal, explains why on many occasions there have been acquittals. Acquittals based on not only on lack of evidence, which is an outcome of any criminal possible outcome of any criminal proceedings, but acquittal based on the vagueness of the law, on the absence of precedents concerning the law. So I will not go more into that, giving examples, but even the law of commander responsibility, for instance, which is one of the main features of international criminal law, has been still not very well settled because the law is uncertain. As of the time of the first cases taken up by the military commissions in the Philippines, trying Japanese, that law affirmed on that occasion has been developed to a certain extent, but still it is not very clear in certain situations whether the law on command responsibility has to be applied in a certain way or in a different way, in particular when one is dealing with perpetrators who are civilians and not military commanders. But Probably one of the main difficulties and problems concerns the law of procedure. It is obvious and clear that the rights of individuals who are brought before a court, a criminal court, must be the same rights before an international court and a domestic court. Principles of law as enshrined in Article 14 of the Covenant on Civil and Political Rights, or to a lesser extent in Article 6 of the European Convention and corresponding articles in other regional conventions, have to be respected fully. From a certain point of view, they should be even respected more than states do, because the treaties on these matters speak of minimum guarantees. It would be obvious that an international jurisdiction would have a role of leader, should indicate to states how they should behave, should first not derogate from the rules, but possibly give some guarantees, some apply standards that are even higher. Now, I will not go into these standards one by one, because they largely correspond to the standards that you find in Article 14 on the Covenant on Civil and Political Rights, which has been generally regarded by the international courts as the guiding instrument in dealing with these matters. But it's clear that one looks at Article 14, some basic principles that are enshrined in that article are not fully respected. The first is the duration of the proceedings. It's before the eyes of everybody that international criminal trial lasts largely more than domestic ones, at the point that when cases have been referred back to domestic jurisdiction in the Balkans, for instance, the same cases, the duration of the case before a domestic court is shorter than what would have been before an international court. This is due to many factors, the main one being the need for cooperation of states. An international court, unlike a domestic court, does not have control over the territory, does not have an executive arm that can implement its decisions, that can bring witnesses or compel authorities to cooperate. And if a state does not cooperate with the court, inevitably the procedures are very lengthy. There is here a problem of implementation of international agreements at the state level, because normally states continue to apply their standards they use in interstate cooperation in criminal matters when they cooperate with international court, which is an erroneous procedure because in the interstate exchange, a state is free to take action. When there is an international court, normally there is an obligation that may come from a resolution of a Security Council or from a treaty to cooperate. And even surrendering an individual does not have to go necessarily through the whole proceedings for extradition, for instance, when there is a resolution, a binding resolution of Security Council imposing the surrender of the individual. But states tend to apply the regular procedures for extradition that may be lengthy ones. Another issue which makes these proceedings very lengthy is due to the prosecutorial activity. One of the features of international courts, criminal courts, is the freedom of the prosecutor in shaping the indictments. And as the perpetrators normally are implicated in a variety of crimes, the tendency of prosecutors is to bring before the court all the criminal activity of an individual, which results in indictments which are very long, with a list of counts which you very rarely find in a domestic criminal proceedings. Now, proving 60 counts is not like proving 1 or 2. One way of speeding up would be to concentrate on crimes, to select crimes, and reduce the size of the indictments. What the ICTY, for instance, has done, changing its rules of procedure, but this has certain shortcomings at the same time, because some counts, some crimes will not be heard at the international level. But I will not dwell on the implementation of all the procedural guarantees, which do not differ substantially from those applicable in domestic systems of law. I would rather take a couple of examples in the case law which show how human rights law may have affected the solution of cases or the way of handling cases. And I would refer to, in particular, to the Nikolic and Barrier-Guisa cases. One heard in the ICTY, the other one heard in the ICTR. But at the appeal level, of course, there is no difference because the appeal chamber is the same for the two tribunals. Now, in short, the Nikolic case was a case of illegal abduction of the accused. The accused was in Serbia, Montenegro at the time, that was the state, was illegally, by unknown persons, brought into Bosnia, where the stabilization force was alerted of his presence and arrested him. Something that happens in international practice. You know very well how many cases of illegal abductions have taken place. And the state practice on the issue of illegal abduction is not black and white. It's not uniform. There are cases in which the person illegally abducted has been returned and jurisdiction has not been exercised by the state of arrest. There are cases in which it has been, this has been done. For our purposes, two cases may be interesting, and they constituted precedent for the ICTY. One is the Eichmann case, the Nazi criminal that was abducted from Argentina by an Israeli commando. And the other one is the Barbie case that was heard in France by the French court. Now, everybody knows that Eichmann was not returned to Argentina. The dispute between Argentina and Israel on the violation of Argentinian sovereignty was settled by the Security Council in a joint declaration before the Security Council, with some recognition of the violation of the sovereignty of Argentina by Israel, but at the same time there was no return of Eichmann to Argentina. And Eichmann was tried by the Israeli courts. And of course, the issue was whether they could exercise jurisdiction in case of abduction. Now, the Supreme Court of Israel came to the conclusion that although in normal cases an abduction would not allow for jurisdiction, when crimes under international law are at issue that should be prosecuted by any country, in such cases, the state would normally have jurisdiction. this was the conclusion of the Israeli court. And the French Court of Cassation came to the same conclusion in the Barbie case. Now, what did the ICTY do in the Nikolic case? Essentially, it took the same position that was taken by these courts. Said, in principle, abduction should not be a basis for jurisdiction. However, when there is an interest of the international community that the person accused of certain international crimes be tried, when this is the case, the interest of the international community has to be balanced against the rights of the individual, and jurisdiction can be exercised. But this does not resolve completely the problem. This resolves the problem of jurisdiction. But what about the violation of the rights of the individual that has been abducted? This right may be set aside vis-à-vis the question of jurisdiction, but is the accused in this case, although the trial goes on, entitled to a remedy for the violation? Because the main principle in human rights law is that any violation entails the right for a remedy. This is enshrined in the Covenant on Civil and Political Rights very clearly in Article 2, Paragraph 3. Now, the tribunal did not disregard this aspect. Simply consider that the non-prosecution was a remedy that went beyond what the accused was entitled to. But an appropriate remedy should be found. And on that aspect, it relied on a previous case before the ICTR, on which I will not go into the details. It was not a case of abduction, it was a case of illegal detention for a certain period, where the tribunal had said the trial may go on, but there should be a decision at the end to remedy the violation. How? In a criminal case, may be relatively easy, because if there is a conviction, one can remedy the violation in sentencing, reducing the size of the sentence because of the violation of the right. And indeed, there are a few cases in which, Nikolic case itself, the trial chamber at the end has been directed by the appeal chamber to, once decided the sentence, to reduce the length of the detention of the accused. In one Russian case in the ICTR, the accused were 3 perpetrators. All the 3 got life imprisonment, but one of them had the life imprisonment reduced to 35 years of prison. So had a reduction of the sentence at the moment of sentencing. The other problem, the other side, is when the accused is acquitted. And there, the only solution that has been recommended by the tribunal is compensation, is financial compensation. This may happen in these cases, or other kind of compensations in kind if possible, which means that the United Nations, in the case of the ICTY, ICTR, the Assembly of States Parties, in the case of the ICC, would have to pay the compensation, would have to establish a fund to pay for possible violations of human rights. On the other hand, even the international community takes up the administration of criminal justice, have to face the consequences. And there has been a case, although, as you may imagine, the decision of the tribunal was not well accepted in New York, especially by the Fifth Committee of the General Assembly. There has been a case in the ICTR in which, indeed, was a case of illegal detention suffered by the accused, followed by an acquittal in the trial, and the legal counsel in New York at the end recommended the Secretary General to pay the compensation as decided by the court. So I wanted to make these cases just to show how human rights law is not just a matter of applying the procedural guarantees, but sometimes affects the way of handling a criminal case. I don't want to be too long. I want to deal with another issue, which is what is to me a clear-cut violation of the covenant that has been carried out before international criminal courts that concern the right of appeal. Right of appeal, there is a right of appeal in all the instruments establishing international criminal jurisdictions, but normally the right of appeal is given to both parties, so to the defense, to the accused, to the convicted person, and to the prosecutor. Now, if it is the convicted person that appeals, there is no problem. The appeal chamber may confirm the conviction or may acquit, and there is no serious issue that may arise. If it is the prosecutor that appeals against an acquittal, what can the appeal chamber do? Because if the appeal chamber convicts on appeal, that will be a conviction that will have no other appeal, will have no appeal. And the principle in the covenant is that any conviction entails a right of appeal. But against that, there will be no appeal. If, of course, the acquittal is confirmed, there is no problem. Now, what international courts have done, in particular ICTY, ICTR, has been to, in certain cases, to convict on appeal and do away with the right of appeal, essentially, which, in my view, is in clear violation of principles of international law, although, for instance, the European Convention of Human Rights allows for that. But the European Convention is a treaty and not necessarily reflects a general principle of international law, as probably the covenant reflects in a larger way. But I will not go, I know we are late in our deliberations, I will not go to explain all the reasons that, in my view, bring about a violation of international law in these cases, because not only you will find them later on in my written presentation, but you can read them in my dissenting opinion, so they're reachable, they're available as of now on the website of the Tribunal. I just wanted to show some lights and shadows of the international jurisdiction, but its criminal courts are at the core of the human rights problems, and what they do to a certain extent goes to improve human rights, but not necessarily in all situations because of the peculiarities of an international